Our next case is Haynes versus Financial. Parties ready, please come forward. Each party will have 15 minutes to present their argument. The appellant may reserve 5 minutes for rebuttal. Ms. Haynes, how long would you like to reserve?
5 minutes.
Okay, very good. I'll be keeping track of that time up here. You have your phone. If you're trying to do that on your phone, that's fine too. But you also see over there on your left, that top blue circle is the one you'd be looking at. So if you only talk for 5 minutes, the most you'll get is 5 minutes for rebuttal. So understand that. Okay, but otherwise I'll keep track of that. And I'll try to let you know if you're talking to me, you got about a minute left. The arguments are being recorded, so when you come up, please stay behind the podium so we can see and hear you well. I don't think this is the case where we have any minors or anyone that we need to refer by initials. But if you were, please refer to a minor or anyone like that by initial or victim. We read your brief and ready to proceed whenever you
are. Good morning, Your Honors. My name is Dominque Haynes, for the record, and I'm here addressing some errors that I felt happened in the trial court. Before I proceed, is there any questions? I'm a little more nervous than last time. It's been 536 days since my property was taken from me with my mother's ashes inside of it. In this time, I seen you, I will call it what was Haynes 1, and we discussed whether conversion had happened or not and whether it was our time to talk about it. In the meantime, because of the many letters that I was getting saying that they were still going to sell my property at this time, although I kept getting the revised letters, and the court judicial officers assured me that that couldn't happen, I filed for replevin because they just never stopped and nothing was being done inside of that lower court at that time. During that time, summary judgment came about in the 3 assignments of errors that I had there. I understand that there are procedures. And as hard as we try, pro se litigants and minorities or people who come here without actual bar member representation, that we are trying our hardest to follow whatever procedure. But in the light of that, we didn't say the specific right word and put it in the right place. Our judicial system is more than equipped to translate and understand what we are trying to say, especially when the things like our property or any rights are on the line. In there, I submitted a motion for summary judgment prior to the defendants in July. It was stricken, it was atrociously stricken, which gave a flip-flop reversal for when they filed their summary judgment. They didn't need to rebut anything that I said with the facts. I provided what I felt like was an authenticated copy of the Title Bureau record. Now, on record, I will say that that lady who provided me that, she did make a mistake, and the Title Bureau did correct the mistake and provided me with another free copy to submit to the court. I submitted it for reconsideration. At the bottom line, if there is still any conflict, Alley Financial's name is on those papers. I was not wrong for going after them when I had no holder in due course in my property on that contract. They should have used their power and their scrutiny to scrutinize that. They seen that their name was on that paper, but yet the affidavit submitted also by Jaquela Smith, a Alley Financial employee, on the record, an Alley Financial, not an Alley Bank, an Alley Financial employee, submitted that they had it. And although the magistrate stated in its footnotes the affidavit was woefully insufficient, it still granted summary judgment to deny the conversion of property with giving them a leeway, saying that they weren't a part of it with their name on it. That deserves scrutiny. If that official record said Alley Financial, I highly doubt that any other company without the permission of Alley Financial come in and just take my things. But that's what happened here. And in order to wiggle their way out of things, they use procedural technicalities. And it's unfortunate that we suffer from those things, from the people sworn to support and to protect those things. I'm sorry, I'm a little off today because I just can't believe it's been that long that I've been fighting for what's rightfully mine for this long. There's no confusion about who was involved in the taking. Their name is on the paper. They should be held responsible. Unduly, they did say they were going.
How did you explain that to the trial court, right? So you're saying, I have the right people. They're
Yes.
here, they should be responsible. How did you show the trial court that?
I provided them a certified copy of the Title Bureau papers, which included the dealer assignment, the original risk assessment, everything that I could find, and everything said Alley Financial.
And did the trial court accept that and make those exhibits, or did the trial court strike those?
Even though I had it listed as exhibit, I didn't do it, I didn't file it correctly. I didn't mash the papers together. I did something that they felt like was procedurally incorrect, although that's what I was trying to express. They bypassed that. They took bypassed the substance and said, hey, you didn't follow this form. Or at least that's what I interpreted as. I must have didn't submit it correctly. They just said they didn't look at it.
Have you looked at the file on appeal? Did these things get in the record for us to look at?
I didn't look for it on file at appeal. I'm not sure how to look at that, but I did look at it in my e-filing portal.
Okay.
Everything that was stricken or anything, it was there.
Okay.
So I'm assuming it said this was stricken from the record.
Okay.
So I'm assuming that it was there. But I did list it as an exhibit. I wasn't sure how to combine it, so it looks like it says Exhibit 1, Exhibit 2. But I also mentioned them in the motion. But that motion was stricken as it was prohibited for me to answer. And I was quite confused because I thought summary judgment was quite a regular answer after they have given their answer. And inside of there, I just rebutted everything that they said because that's what I was supposed to do, because from my knowledge that if you don't rebut anything, it stands as true. So I'm not a lawyer, but this company took my stuff with my mother inside of it. I asked for it back. And like they said, many have tried, many have lost, but I will not stop until they pay for the taking of my stuff. They can't take anything from us without coming through you first. That's due process. And it's not waived at anything. I see that many people are saying that if we don't say anything, we waive our rights. Our rights are preserved here in the United States as Americans. They're not waived under any circumstances, and I especially can't do that unknowingly. Especially when I'm sitting here, my heart is trying to preserve the little piece I had left of my mother. I can't get that back. So that's all that I have to say for today, and I reserve the rest of my time. I'm sorry. Any questions?
That's okay. We would have asked if you had. You're fine. Thank you. Thanks.
Thank you, Ms. Haynes, and good morning. May it please the court, your honors. Joel Seckler on behalf of the defendant, Ally Financial. Ally Financial is the defendant in this case. They aren't asking anything from Ms. Haynes. They did not sue Ms. Haynes. We put into evidence that Ally Financial, both through its answer and through summary judgment affidavit, that to the extent your vehicle was taken, Ms. Haynes, it was not us who held the contract, and it was not us who ordered the repossession. Under Rule 56, it was Ms. Haynes' obligation as the plaintiff responding to that to put evidence to the contrary in the record. I understand she feels very passionate about this case, but she never put any contrary evidence in the record. She made unsworn arguments in her briefing. She attached some unauthenticated documents to some briefing, but there's no actual evidence in the record contradicting that Ally Financial has nothing to do with the contract.
Why did the court strike her?
Well, to the best of my recollection, there were three documents. One was a dealer assignment of title for the vehicle. One was then the initial title for the vehicle itself, but I want to say the other one was like a warranty contract, like a purchase of, like if something happened to the vehicle, the warranty company would come in and pay for repairs. But again, none of those were authenticated either by affidavit or by any other method allowed under the rules.
And were those then, as she's describing, attached to some answer, or something called an answer to summary judgment that was dismissed, or stricken from the record, or that in the record somewhere?
Well, and again, I think I understand what she means, and she can obviously clarify for herself. But I think there's two separate issues there, Your Honor. They were attached to what I believe she called her memo in opposition to Ally Financial summary judgment and her own summary judgment motion. What she's talking about that was stricken, I think, and again, I don't want to speak for her, but since you asked, I'm going to give my best chance to answer. I filed an answer on behalf of Ally Financial. She then attempted to file a response to that answer, and the court said that under the civil rules, there isn't an answer to an answer. So it struck that document, that everything she filed, either affirmatively for summary judgment for her or affirmatively in opposition to the summary judgment motion I filed, remained on the docket and was not stricken, to the best of my knowledge. I believe that is true.
That first item that was stricken, did that include the documents that she was alleging said Ally Financial on them?
I won't say with 100% certainty, Your Honor, but I believe the answer to that is no. I think it was just a written pleading of her own, just saying, this is what I think about how Ally answered this paragraph, or this is what I think about this affirmative defense that they raised. To the best of my recollection, there weren't any attachments to it.
And those documents would have been attached to her response memo in opposition to summary judgment, or whatever she called that filing. That's where these documents you're saying were attached, you're saying they weren't properly authenticated and all that, but that's where they were attached.
Correct, Your Honor. And in fact, Judge Baker Ross in her decision referenced them as being attached and saying, I didn't consider these and I can't consider these because they don't meet the Rule 56 standard for authenticated evidence.
I recall that. I don't know if they ever got in the record at any point in time, and I sit here trying to look at the record on appeal to see if they're there to review.
To the best of my knowledge, Your Honor, they were attached to what you'll see is her memo in opposition to my summary judgment motion, which was a combined summary judgment on behalf of her. I believe that's the case.
And you would say fairly they should be part of the record on appeal if they were attached to that motion?
Yes, no, and we did not object in the trial court, and I am not objecting in that regard now. So the main point is that I would make while I'm here is one of the things that Ms. Haynes said is they cannot take my vehicle without coming through you, meaning the Court of Appeals or the trial court. And I said, I would respectfully disagree with that. Though my client, Ally Financial, there's no evidence they were involved in the repossession, but let's assume for purposes of this argument that I would be free to stipulate that Ms. Haynes is right. Ally Financial was the holder of the contract when the repossession happened. Here's what happened. She signed a contract. It's assigned to Ally Financial. That contract says, we're extending credit to you so you can buy a car. You're agreeing as part of that contract that in order to buy the car free and clear, you've got to make 75 monthly payments. There's no dispute she made 13 of those payments and then in February of 2022 stopped. The contract she signed, paragraph 3C, expressly says if you stop making your payments, we can come and take your car. She stopped making the payments. Whoever was the holder of the loan came and took the car. There's no allegation that there was anything happened. Ms. Haynes just looked out the window and said, realized your car was gone. There wasn't a scene, police weren't called, no disturbance of the peace. And then after the car was repossessed, she got the notice that's required by Ohio law saying, we repossessed your vehicle. She admits she got at least the fourth one. There were 4 sent to her because the sale kept getting rescheduled. But it sounds like she's admitting this morning she got at least most of them, if not all of them, saying, look, we repossessed your car because you haven't made your payments. If you want your car back, it's at this location and you need to pay this amount of money. If you don't pay this amount of money, then it's going to be sold at this location on this date at this time at public sale. She didn't pay the amount necessary to get the car back. The car was sold at public sale at the exact date, time, and location she was told it was going to be sold. She didn't show up and bid. This is what happens every day. That's what Ohio law is.
Counsel, what happens to the contents of the car?
Well, the notice it gives tells her where the car is, and if you want to get your contents, call this number, show up at this location, they'll be given to you. That gets into an area that involves the company that holds the car, and so don't quote me 100% on this, but I've been doing this long enough that typically the contents will be collected. They'll be held for 30 to 45 days, and if the vehicle, the borrower or the person who has the vehicle doesn't come and get the contents, they're typically destroyed. I can't tell you with 100% that's exactly how it went in this case, but I know that's how it's typically handled. And whether it's Ally Bank or Ally Financial, that's something that they leave to the repossession company and to the company that auctions off the car. They have their policies and procedures of how they do that. But the one thing that, at least on this record, both in Haynes 1 and in this case, is there's nothing in the record to suggest that Ms. Haynes tried to get any of the contents that were in the vehicle, or called the repossession company, called the auto auction, tried to go out. And again, if she had done that, whether it's Ally Financial, Ally Bank, or Joel Seckler Bank, who has the contract, we're not going to stop her from doing that. We don't want the contents of the car. But there's just no evidence in this case that she tried to do that, let alone that she tried to do that and someone prevented her from doing that. So, I mean, at the end of the day, this is just what happens with a car loan. If you take out a car loan and you stop paying, your lender's going to repossess it, and if you don't pay the amount to get current and get the car back, they're going to sell it. And that's, if for whatever reason Ms. Haynes couldn't afford to keep making payments, I hate to see anyone in financial difficulty. I hate to see anybody that can't pay bills. But whether it was Ally Financial, Ally Bank, or some third party that was the holder in this case, even if you assume Ally Financial, she's right and Ally Financial was the holder, they didn't do anything wrong. They just did what the contract in Ohio law allows them to do.
And the trial court's ruling was basically you haven't proven Ally Financial was a holder, that's the party you represent, therefore the case is dismissed.
Correct, Your Honor.
Yeah, and I appreciate your explanation, but that's basically what the court said.
That is what the court said. I'm just saying here, and I know courts of appeals do this sometimes, I'm like, you can affirm and say, and I think you should, that Judge Baker Ross got it right, but in any event, even if Ally Financial was the holder, there's no claim here, because all they did was repossess a vehicle they had a right to repossess, and they gave all the notices to Ms. Haynes after they did the repossession that they were required to give her. This is just a textbook legal repossession in Ohio. So unless there's any other further questions from the panel, I waive the balance of my time. Thank you for your attention this morning, and request that the decision be affirmed.
Seeing no question, thank you.
Thank you, Your Honor.
Ms. Haynes, come back up. You have 5 minutes, it says 7:53, but you can only get 5 minutes for rebuttal.
No problem. I want to address one thing. The motion that we were talking about was filed on 7/8, and it was titled Motion for Judgment and Relief. And what was included was with the little blue mark with the title bureau thought they gave me was an authenticated or certified copy of the title bureau record stating Ally Financial. I also want to address, it is true in their record that I was given communication of them not letting me get my property, which I also did file a lawsuit against the company that actually took my car. There is proof. I did call the police. All that's there. And I understand that
that part of this lawsuit, or is that a different lawsuit somewhere else you're suing this company?
The lawsuit is for source one is different from this one.
Okay.
This was because
Understood. I just wanted to make sure I didn't see any of that here. I wanted to make sure that I wasn't missing anything.
You know, if a company's right, say I did get a loan from Ally Financial. If they're right, if they wouldn't have no problem coming to get my stuff themselves. This was ongoing and requesting for them to file a civil action because I did not owe them anything. There was no holder in due course. Our financial wasn't sitting there when we signed it. Not only that, I provided the law itself that said, if this notice is here, there is no holder in due course. That means someone expecting payment. They wouldn't go through all the snafus of trying to do the sovereign citizen move of changing their name and now I'm no ball and now I'm this. I tried for 2 years to bring them here so they could prove that they were a holder in due course or get off of my title. They're not. So then they tried to pull the snafu, knowing that, hey, the chances are she won't have the legal knowledge to uphold anything that we're doing. I don't owe them. I never owed them anything per that contract. It's there, we can't erase it. But what I do know is that alley, that family office tortured me along with in the courts. Why? Because they have been upholding these two entities, switching around and taking people's stuff without any sufficient assignment, period. The lower courts have been upholding it. It's only one magistrate, one down there, who had the gonads to stand up and say, no, this is insufficient. Just one. Just one. And that's horrible. It was insufficient, period. And after I proved that there was no holder in the courts, my judicial system, the one that we uphold, that give you all these privileges and immunities, you should have helped me. It was plain on its face. There was no reason for Cletus to put it in the footnotes. He should have put it on the paper that said it was insufficient, period. And then we would have assessed that contract and we would have looked at that notice and we would have went straight to the Ohio Revised Code that says no holder in due course, period. My mom is gone now in a landfill somewhere.
Did you receive notice that you could go pick up belongings?
I received the first one at my house and the court took the original copy. And that was in the towel case. That was the only one I received. And after I received the stack of papers from the P.O. box, even though I asked them to make sure that they said anything to me through email because I didn't have any access to the P.O. box, when I did, I emailed him and Alley Financial in a joint thing that said, hey, because Circe told me that there was no way they could sell it. We're under litigation. There's no way that they can do anything. I took it as her word, but I should have made them put it on the record, but they still did it anyway. But what it was that they were confirming that they couldn't do nothing was that why they kept sending me revised notices because they couldn't do anything. So I actually never knew for a fact that it was sold until he put it on the record in court that it was sold. I never received a confirmation letter like, hey, we sold your car for this amount of things, for this amount of whatever. I never received anything like that. I didn't actually even know it to be a fact until he put it on the record in court. So at the end of the day, that summary judgment, it should have been denied anyway because there was a conflict in the evidence, period. It was attached to that 7-8, which she struck and tried to construe it to be something that it wasn't, or just claim it to be an answer when it said motion for summary judgment and relief. And she struck it, and then a couple days later, he files his summary judgment. And according to the rules, now I have to rebut that sufficient evidence. And all I did was submit the same exact paper that I submitted on the 8th. That's all that I did, because it was already enough in that record.
So your submission of a summary judgment motion was on August 8th, right?
Was on July 8th.
Okay, that was stricken, right?
It was stricken.
And then you filed a motion for summary judgment on
With
August
the same
8th?
thing on August 8th.
Okay, thank you.
But it was there. Ain't nobody coming this far to play. They're big enough that they would have never changed their name or ever did any snafus because the way, like he said, procedure has been going on so long that we have been put in this adulthood to transfer some rights that if we took the time to read it, they never had the right to do anyway. And once we knowingly now know our rights, we have every right to assert them, just like that paper said that they are subject to every claim and defense we can assert. And I did. And that's all. They owe me from my mother and my car because I didn't owe them. And they bullied me out of my stuff using my courts. That's all.
Thank you, Ms. Haynes. The court will take the matter under advisement and issue a decision in due course. With that decision released and mailed to you by the clerk of court, and can also be available on the court website. With that, on behalf of the court, I'd like to thank both of you for your presentations this morning.
Thank you.
Thank you.